She charged with stabbing him. There were only two people in the room, him and her, and he didn't have a stab wound when he entered the room, and he did at the end of the altercation, and no one else had come in. I actually went, read my lips. I cannot win this trial. The things about murders is usually the main witness is dead. So the juror thought, well, there's two opposing stories and they both make sense. We'll ask the deceased. And they brought the Ouija board into the jury room and they set about having a séance to try to communicate with the deceased. And part of my job then was to keep the bastards honest.
In part 2 of my chat with former criminal barrister Judith Fordham, Judith continued to entertain me with stories from the bar table. Judith also took us inside the jury room, and some of the things she said might make you question whether the jury system has had its day. We also found out how Judith defended a client who was accused of stabbing the person, a case that she thought was impossible to win. And we had discussion about forensic science in the criminal justice system. This was a really unfiltered look at the justice system. I think you're going to enjoy it as much as I did. Judith Fordham, welcome back to part 2 of I Catch Killers.
Thanks for having me back after the first part.
Well, we considered that we had a discussion off mic and we said, no, we'll let you back for the second part. Can I ask you about you winning the unwinnable case? And the way you described it to me was you're perfect, that you're representing a client that had gone into a room and got into a fight with the person in the room. The person hadn't been stabbed when your client walked in the room, and when your client walked out, the person had been stabbed in the back.
In the back.
Take it
you
from there.
can't stab yourself in the back, by the way. I have won trials where
pretty hard.
We ran the defence, he cut his own throat, and that's been successful. But you can't do he stabbed himself in the back. It's just not going to work.
Yeah.
This is a client who came in to see me late in the day, and she won't mind, if she's still around, she won't mind being identified, I know, because this may identify her to someone who actually knows her, but she won't have a problem with it.
Yeah.
She came in and she walked into my office, and I'm sorry, but she wasn't very well dressed. And there's a reason that I say that. She was looking pretty daggy, and she'd been a gem fossick or opal prospector in an outback town where they have gems and opals there. I'm trying not to identify things. But she was a transsexual. And sadly, because many transsexual clients I've had have got wonderful dress sense, she was standing behind the door when dress sense was being handed out, as my mother would have said. And so she came in looking pretty daggy with terrible taste in makeup and clothes and everything, but she was very upset. And she came in and she said, I don't want to go to a men's prison. And I said, well, stop a minute, how about you tell me what you're supposed to have done? Or what you haven't done is how I often open an interview with a client. Tell me what you haven't done. Tell me what they reckon you've done. So I just don't want to go to a men's prison when I get convicted. And I said, well, let's just see if you're going to get convicted first. And as time went on, I was starting to agree that she would get convicted because what had happened, the background to the story was that she'd collected a whole lot of gems in her prospecting days. And by the way, she had to be pretty tough because if you're going to be in an outback town like that as a prospector, it's a pretty rough and tough blokey sort of a world. So she was pretty handy with a fist, had to be. And she was big too. She was probably 6'3" and quite solidly built. Now, she'd got all these gems and she'd come to Perth and she'd made these dreadful souvenirs. I'm sorry if you're listening. I'm sorry I called your souvenirs dreadful, but they were. She'd made these Jarrah maps of Australia, varnished them, and what you do is you araldite on a precious stone where each state capital is. You leave Tasmania off because that's just too darn hard. You can't do that. And you flog them as souvenirs and you make money. And she was going to make money for her gender reassignment surgery. It's not sex change, it's gender reassignment because you're being assigned the gender that you've always felt you were, okay? And she went to a fairly cheap boarding house in Perth with all her Jarrah maps of Australia, and she met this young man who was quite personable, and he said, "I'll sell them for you. You know, I reckon I can get you about $35,000 worth for this lot," or whatever the amount was. And great, she was impressed by him. Okay, you take them and you sell them. And he came back later on, and I think he only had about $1,500, and all the maps had gone. And it's like, where's me money? Her money was probably up his arm, I suspect. You know, it was in the days of heroin, I seem to remember, where he would have injected himself and blown a lot of the money and brought back what was left. And she was pretty angry. And they had a really intense argument about this in the sort of lounge area of this boarding house, and it devolved into a fist fight. And as I said, my client was, you know, really could handle herself in that situation. She wasn't charged with thumping him, though. She was charged with stabbing him because although there were only two people in the room, him and her, and he didn't have a stab wound when he entered the room, and he did at the end of the altercation, and no one else had come in. I asked her all of this. Did anyone come in? No. Did he have a stab wound when he came into the room? No. Did he have one at the end? Yes. Did you stab him? No. I actually went, read my lips. I cannot win this trial. You are going to have to plead guilty. I mean, which is sort of an answer to how do you defend someone you know they're guilty. I tell them to plead guilty. I tell them they're insane if they don't. She said, I don't care. I didn't do it. How do you get the stab wound? I don't know. Like, read my lips again. And I still didn't know how I was going to win the trial, but she insisted on going to trial. In fact, her main question was, what do I wear? She said, will I come secretary or will I come astronaut? And I said, well, come secretary. That was a mistake. I should have said astronaut because, I seem to remember she was wearing blue sparkles and white gloves. I could be wrong there, but it just... But astronaut would have been worse, I guess, because it would have been a silver lame. But anyhow.
Would have made a statement.
But anyhow. So I'm at the beginning of the trial, and how am I going to defend her? And I'm looking at the crime scene photos again, just as you do, going through everything you've got. And it dawned on me, and thank heavens it dawned on me before the trial and not after, because I could never have forgiven myself. There were some stairs leading from this room. And no, it wasn't that somebody came down the stairs. It was stairs leading from this room upstairs to the kitchen. And I said to her, where do the stairs go? Oh, to the kitchen. There was a plastic bag on the stairs, just like a Woolies bag or a Coles bag, something like that. And the bag looked like it had been damaged. It had you know how they're made of not great plastic, and it had like a split in the back. I said, whose bag's that? She said, it's mine. I said, well, what was in it? She said, oh, it was me dinner. I was going to go upstairs to the kitchen and cook me dinner. I said, so what was in it? She said, me bread and, butter or margarine or whatever, and me steak and, me fork and me knife.
Uh-huh.
And there's a split in the bag. I worked out what had happened. They'd had a punch-up. He'd fallen back on the stairs. The knife was in the bag at such an angle that he actually fell on the knife. The defence was he fell on the knife. Luckily, he only had one stab wound because you're not going to be able to run. He fell on the knife, got up, ran backwards and fell on the knife 4 more times.
Yeah.
But he...
Well, that would have been a hard one to explain.
Yeah.
So how did that play out at the trial? Did the trial commence was there...
No, the trial commenced and she gave her evidence and we explained to the jury why she looked the way she did because they would have been wondering. And she gave not the explanation we'd rehearsed, but another explanation. I
Yeah.
said to her, because we had to explain what the money was for and why she was so upset, you see. So it was actually an essential part of the background. So I said, what was the money for? Why were you so angry at him? Because she admitted hitting him. She wasn't charged with hitting him. She was charged with something called unlawful wounding. I probably should have said that, which involves stabbing.
Mm-hmm.
So she wasn't charged with punching him. So why were you so angry? He stole me money. And what was your money for? It was for me operation. And what was your operation for? It was for me, gender reassignment surgery. And what was that for? And she was supposed to say it was to make me look more feminine. In fact, she was supposed to, I was going to ask a leading question. I was going to say, was it to make you look more feminine, which is technically a leading question, but no one was going to object. So I knew I could get away with asking it. Was it to make you look more feminine? But she forgot what she was supposed to say. So I said, was it to make you look more feminine? She said, nah, it's just going to cut me dick and me balls off. Nothing's going to make me look more feminine. And I went, you could have heard a pin drop. The judge glared at me like, this is all my fault. And
You instructed her.
That. I hadn't at all. She was supposed to say it's to make.
Oh no, but you instructed her to say what was appropriate or the way, and she. But you can't. Yeah, it makes for courtroom dramas. Things
but
like that.
I reckon my little theory is that the jury thought no one could give an answer like that and not be telling the truth. I reckon it probably impressed the jury.
I've seen witnesses that come in there and or people involved in trials that they're too stupid to lie.
Yeah.
Like in the way that they're giving evidence, and that's sounding like I think I'm smart, but there are some people that are too stupid to lie, and like I would have legal people come to me and say, well, why do you think they're telling the truth? I don't think this person is capable of telling a lie. Sit down, have a chat, and you'll understand what we're talking about.
Continuing the lie, and getting away with it. You can tell stupid lies, but you'll get sprung.
Yeah.
You've got to have a certain degree of intelligence to carry the lie through and to make it consistent with everything else. But
and consistently keep
anyway,
that going.
This jury came back in 17 minutes and acquitted her in 17 minutes. I timed it.
High fives?
Absolutely. Yeah, and she gave me a necklace which I've still got made out of a crystal that she'd mined and erudite into something. Yeah.
Are you wearing it today?
But I do still have it and I treasure
All right.
it.
Okay. Look, things like that makes a battler for a whole range of reasons, but little things like that make a difference, and you could have potentially missed that.
Oh, yeah.
And lost that, so that must give you some sort of feeling of you're doing good work.
I was really pleased, but most of me was going, thank heavens I noticed it before the trial, because I beat myself up about the things that I mess up. Because honestly, she wasn't guilty. She absolutely wasn't guilty. And she should have been acquitted, and I'm glad the jury did it so quickly. But it was almost an accident, and I don't like that. I don't like accidents.
Don't like it coming down to the wire. Yeah, I want you to take me into the jury room now, and let's. I think we touched on it in part one that generally jurors in this country are not allowed to speak about what goes on in the jury room. So it's a big mystery. The jurors are shielded from everyone involved in the trial, and they're brought in down the back alleys, and they're not allowed to talk to anyone. So it's very rare that people working in this field get an opportunity to talk to jurors. How did you come to get that opportunity?
Accident. There seem to be a lot of accidents happen in my life. I was doing a postgraduate degree in forensic science, as you do when you've got nothing better to do with your life, or have so much free time. And I was invited to do a PhD, and it's
the kids can look after themselves. Don't worry about that.
I'm fond of saying that mine thrived on neglect, and again, it's sort of a fairly sick sense of humour there.
You're toughing them up for the life that
Look, not one of my children has a criminal record, so I call that a success.
or you are a very, very good barrister.
No, I call that an absolute. Anything better than that is a real win. But no criminal record.
Fantastic.
Yeah. Anyhow, accident was what happened. You got to do a PhD. And when I did my postgraduate work in forensic science, there was no such thing as forensic science for lawyers. I had to do a proper postgraduate science course. And honestly, yes, I had a science degree, but mine was biological sciences. And, I was having to learn forensic chemistry. I didn't do, last time I did chemistry was at school, and I wasn't very good at it.
And that was scary.
Yeah. So what am I going to do a PhD in forensic science? What on earth can I do? I don't actually know enough science. So jack of all trades, master of none was me. I thought, I know, I'm going to do expert evidence because that sort of straddles the worlds of law and crime. And I thought, I'm going to see whether I can talk to jurors, because we always wonder, you were saying earlier in part one, these jurors sitting there, have the lawyers and the experts lost them? The lawyers and experts having their own learned conversation. The jury's sitting there going, what happened? What's going on? Have they forgotten about us? Because the jurors just happen to be the most important people in the courtroom, and they get forgotten about. So I thought, I want to know what works. I want to know what type of communication works. How do they wrap their heads around it? Do they go out and do their own investigations, their own research? And we know that that's a complete no-no. You mustn't go out and do your own research and bring it back to the jury room, or if you get found out, the trial will be aborted because you're supposed to only rely on what's presented in court. So I'm curious about how they handle expert evidence. And the only way to do that, because it is against the law to talk to jurors after trials, except with the permission of the Attorney General. So I went off to the Attorney General of the day and said, I'd like to talk to jurors and I'd like to find out about this. And he was very receptive and gave me that permission, and it became a very, very big study. In fact, I think it's the biggest study that's ever been done. Certainly in Australia, UK, Canada, all the law systems that are very similar, where you're not allowed to, for example, you don't have the jurors being interviewed on the court steps like they do in the US. And I had a lot of support too. The Law Society was in support. The police actually gave some funding towards it. Legal Aid gave some funding. The Department of Justice funded it. The Sheriff's Office cooperated with me and sent out 3,000 questionnaires. That way, you see, the jurors could remain anonymous unless they opted into the study. So they sent them out. I didn't know who they were sending them out to, except it was random. And then jurors opted in. And the amazing thing is, it was a 24-page questionnaire, not just tick a box. It was, write down what happened here and what happened there. And, approximately a third of the jurors actually completed that form and sent it back, which is an amazing response rate for a complicated form. And of those, until the funding ran out, we interviewed something like 500 of them. And so...
Wow, that's a big cross-section.
It's huge. But in the process of that, obviously, I learned a lot about what goes on behind closed doors.
Take us there where you can. What goes on behind the jury door?
Well, one of the things that came up, because it became not just expert evidence, it became a whole jury experience study. It grew and grew and grew. One of the things that I learned was, people say, the jurors would have acquitted this person because he's evil and they're scared, and, it wasn't because there wasn't enough evidence. It's because they were scared of this bad dude. It was in fact always, I didn't find one instance where a juror said, and I do believe they were being honest with me, they had to opt in for starters, where a juror said it was because I was scared of this bad dude, that's why I acquitted him. No, it was because there were significant gaps in the prosecution case, and the prosecution was relying on the fact that he's a bad dude to get a conviction, and the jurors took their oath seriously and would only convict if there was, in fact, enough evidence. Now, that's a jury doing their job and doing it properly. It's sort of, on a different topic, which I'm sure we'll probably end up touching on, it's sort of why I can sleep at night believing that my client was a bad dude, but he got acquitted, because as I said at the start of the thing, part of my job then was to keep the bastards honest. I did come across quite a lot of examples where the jurors actually went out and did their own investigations, which they're totally not allowed to do. And that was usually because they had questions that they wanted answered and neither side had given them the answer. Because, of course, a trial is about who presents what evidence on the day. And there might be good reasons why certain evidence is not being presented. For example, if someone has a really bad criminal record in things that are not logically to do with whatever they're accused of this time, often the jury won't be told about that because the theory being that they'll be influenced by that and convict him without the proper evidence. I actually don't believe that'll happen. I do believe jurors do a really good job, I've learned, generally. You know, you've got the occasional rogue jury, but again, that's another story. But they have gone out and, for example, gone to the scene of a chase or a traffic accident or even a nightclub where something's supposed to have happened, and they will report back and tell the other jurors what they did. I had them conduct experiments where they've, thrown things out of the window of a moving car to see how far away they land. Now, maybe we should have had someone give that evidence so they're not tempted to do that. And no, I couldn't and didn't and wouldn't report that because everything they told me was confidential. And you can see I'm being very, very careful not to give any identifying information about a particular trial. Yeah.
With you talked about past criminal history and the jury not being given that because that might influence their decision. Use an example: someone's been committed of an assault years ago and then been charged with drug-related matters or whatever. It could be that. Is that going to influence the jury? I'm a big believer, and we had this chat off mic the other day that. All the information that's kept from the jury, we put our faith in being judged by our 12 peers or whatever, and that's the basis of the jury system. I have concerns that not enough information is put to the jury and we don't put enough faith in the role of the jury to make informed decisions. Like they're told not to, the only thing that they need to take into account in deciding guilt or innocence here is the information that's been presented to the court. They still get instructed not to, it used to be, don't watch the news tonight if it was a high-profile case, don't read the papers. And they go, as if they're not watching the news or reading the papers about it. And now they're instructed, not to examine this on social media and different things, as if they're not doing it. I think we've got to say there'll be reports in the media. Don't put any weight on that. That's unsubstantiated information. What you need to do is concentrate on what we're presenting to you at court. We need to make the instructions more respectful to the role that the jury have, I think.
If we're going to have a system that completely relies upon them, then we've got to have some trust in them. And as I said, most of my research uncovered the fact that they can generally be trusted. And they will have arguments in the jury room. No, you're not allowed to think about X, Y, Z that you've learned, and what the media reports will be sensationalist, might not necessarily be correct, and we have to only take into account what's said in the jury room. And remember, I said in part one about this jury 40 years ago who said we understand that there might be some new work out on what causes ulcers, but we weren't told about it. We wish we had been. Now, that we were forced to convict even though we didn't feel happy about doing it. So they will do as they're asked generally. But that leads me to another thing I learned, and that is that there are really two types of juries. There are evidence-led juries and verdict-led juries. And the evidence-led ones are the ones that produce the most satisfactory verdict. And by satisfactory, I mean they've actually considered the evidence and come to a conclusion because the evidence takes them there. And I'll just explain that a bit. You get
if you could.
You get the sort that will go into the jury room. Someone has volunteered to be the four-person, offspring, in charge of, the communicator of the jury to the court, because that's really all they should be doing. And it'll often be the person who really, as they've seen on television, they just really want to be the important. And they've got fixed views about what happened, and they're going to get this jury to do what they want. That's why I think four persons should not be chosen until a couple of days into the trial. And some judges do that now. Some judges, I think, have that point of view.
That's just a subtle change, but I think that's a worthwhile change, because you could imagine the 12 people sitting down there, and whoever thinks I'm smarter, I'm quicker, bigger, I'm going to take control of this. And then you get that bully type or domineering type that will influence the other people. So, okay, sorry I interrupted, but the judges are now wake up to that. You don't need to pick it straight away. Just feel the dynamics of the group, dynamics of the room, and then work out who you think is best suited as the
particularly with a longer trial, you've got the luxury to be able to do that. I think it's a good idea as well. But a verdict-driven jury, not led, verdict-driven jury will be one where, the foreperson says, right, let's take a vote. Who thinks he's guilty? Who thinks he's not? All right, 3 of you think he's not. 9 of us think he is. How can we pummel you 3 into submission? How can we make you see our point of view? What's your problem? And that sort of thing will happen. And I've heard tales of jurors lying on the floor crying because of the amount of bullying. Now, that you have to say, if there's a verdict of guilty after that sort of treatment, that's not satisfactory. And I measured it by asking jurors whether there was anything that happened that influenced them to vote a certain way, which they later regretted, in the cold light of day, if you like. Now, that's your verdict-driven, and that has to be, in anyone's book, unsatisfactory and not necessarily going to do justice. Then you've got your evidence-led, where people say, right, okay, we've been told what pieces the prosecution has to prove, what the elements of the offence are, what things they have to prove. Let's look at each one. What evidence have we got that relates to that, pro and con, what did this witness say? What did that witness say? And go through it, carefully and thoroughly. And they find sometimes, even though, for example, their sympathies might have been with the victim or their sympathies might have been with the accused, the evidence takes them to a particular conclusion. Yeah. That's got to be far more satisfactory. So one of my recommendations, if I hadn't had publication stopped by a change of government, one of my recommendations was going to be that there ought to be a facilitator in the jury room, someone who's just experienced at holding meetings, if you like, and getting people to some sort of agreement.
This is going to say shallow when I say this, and I was thinking as you were talking, describing it, I wasn't going to say facilitator, but I was thinking that exact thing, that if you had someone there that could just keep them all in line, and they'd have to be the right person with the right personality, just explaining what the role is there, because I could see a group of 12 people going off in completely the wrong direction. So what you're saying, facilitator, I think that's you're onto something there, because I think too much is asked of jurors, because I sit there on cases that I might have worked on for years, and I'm getting confused as the legal argument's going. I'm sitting there going, I'm getting lost on this, and I'm thinking these people have just come into it. I've lived and breathed it for months or years. Understand the broader picture, so I've got a better starting point. You've got these people that get this sanitised version of information. They're asked to leave the court of voir dire going on. There's a legal argument in the absence of the jury, and they must be sitting there going, what are they talking about? Then coming back in and not being informed of what was discussed, other than a look at something that wasn't relevant to your role here. We're sorry that we're asking you to leave the court, but could you now leave the court? And they sit in their jury room for 3 hours, probably guessing, what are they going to ask this witness?
I can tell you from my work that they are guessing that, and they're offended as well. Why are we not trusted? Why do we,
Yes.
They think we're children. They think we can't actually, sort sort things out. Also, it used to be, not anymore, thank heavens, that jurors were even told not to take notes. Now they can take notes, and some judges will allow them to have copies of the transcript, in other words, the typed up version of what's said in court.
Yeah.
Why should it be a memory test? Why should the person who misremembers something hold sway in the jury? Why should it be just the person who took notes that, is the one who has more influence because they've got notes? They only took notes of what mattered to them. So access to transcript, and people say, they'll just get bogged down or, Well, how about putting a bit of faith in them? And if they want to check something, rather than having to come back into court, which is what often happens, to have transcript read to them, why shouldn't they have it searchable on a computer in the jury room and look it up for themselves?
Well, I think it's evolving and changing with the times,
yeah.
and it should be something, because the jury system is, the lineage goes back hundreds of years. The world has changed. And it used to be, we'll call the jury from the village because you're going to be judged by your peers, but it doesn't sort of really sit that way anymore. There's a whole cross-section.
It's only relatively recently that women could be on juries.
When did they? I didn't realise they let women into juries. When did that happen? That's outrageous.
Gary.
Oh, right. Well, that's When did that come? When was it 12 men? How long ago was that?
I don't actually know, to be honest, which is embarrassing. But back in the 30s, for example, it was always just men. I don't know when it actually changed, but don't forget that women couldn't vote at one point. We only get to know the person's occupation, very little other than that. Their occupation. The suburb they live in, unless that's changed, and very little else. And all you could do is to say, well, I guess if you're defending a bank robber, you wouldn't want a bank manager on the jury. And it used to be you wouldn't put teachers on the jury because the theory was they'd be too judgmental. One other thing I've learned from my study is the more educated the person, the more useful they are as a juror. And, give me a teacher any day on a jury, even though the received wisdom was you don't put them on juries. That's just probably due to people's bad experiences when they're at primary school or something, I suspect. I don't see any.
Let it go.
So, the more educated they are, the more able they are to indulge in that intellectual exercise of putting aside preconceived notions, of examining their thinking and being critical of their own thinking. And I mean critical in the good sense of the word.
Do you think it would get to the stage where we're not having the jury trials? Like, I know there's options there. You can have a judge alone trial. Do you see it evolving to the point where, look, this is all getting too complicated? Forensic evidence, scientific evidence, even AI coming into play. Do you see the courts evolving? Will they keep up with the times?
Look, I still think there's a strong argument in favour of having. Are they your peers? That's another question. But having a jury of, 12 people who are not otherwise involved in the criminal justice system to actually judge this, because in the end, it's society that's punishing or acquitting somebody, and they're representatives of society. I think we need to get better about how we communicate information so that things don't get too complicated. And the forms we presented in, should we be giving them visuals? Should we be giving them, graphs? Should we be giving them pictures? Should we learn to communicate? Like, I'm a great, wonderful scientist and I can talk fancy language and I can use fancy terms and all my colleagues understand me. Well, how am I going to present this to a jury? How am I going to explain this so they understand? And I firmly believe you can. I believe people can be trained not just to ask the right questions of them if you're the lawyer end of it, but as the expert to use the right language and to explain and to have, the lawyers help them explain it. So I think the answer's in the training, and I don't think just having a jury of, say, 3 accountants in a, fraud case is the answer at all. And with judges, I mean, you can't pick which judge you get. Judges, I have to say the quality of judges is improving a lot a huge lot over my career. But, back in the olden days, I would be very nervous if I had a judge alone trial, which judge I would get, because some judges, you knew that they were going to convict. Some judges...
They had strong leanings one way or the other, the type of judge.
And so you'd only go for... The ability to have judge alone trials is a relatively recent innovation anyway. And I did it in the baby shaking case because at the time of the trial there was actually a public information campaign about don't shake your babies, which...
Okay, so that could have played played
worried
into
me.
The minds of the
and
jury.
I was glad that the particular judge that we got was a thoughtful, very fair judge. He may even recognise himself, but, I was very glad about that. Whereas I remember one particular judge, my client actually passed out in the dock because he was so drunk. That's after they found him and got him to court because he didn't turn up the first day because he was on a bender. And he passed out and I said, Your Honour, have to ask for an adjournment because my client's sort of unconscious. And the judge said, Miss Fordham, he'll sober up and you can, as the day goes on, you can tell him what happened. And it's like...
you're not shocking me there, but different.
I said to the judge, look, I've never been asked to justify this, but I thought there was some sort of rule that the accused had to be conscious.
Yeah.
Anyway.
Well, I can imagine it. I can imagine it happening there. Would you ever? And it's a huge question. You don't have to. Dig into it too much, but we've got the adversarial system, which is not actually a search for the truth. It's proving the guilt or innocence. And then we've got the inquisitorial system, which is a search for the truth in basically finding out what happens. Some countries have that system in place. Do you think it's a better system? It's a big question. I'd just be interested in your thoughts.
We have that in the coroner's court, where the coroner can actually direct investigations, and it is a search for the truth. And coroners are specially trained to do that. And I think certainly in the investigation of deaths, where it's not an attempt to pin blame on someone, or certainly shouldn't be, I think that's a good system there. But other countries, I've been a member of the Law and Society Association, where some of the work they do is on justice systems, and you compare systems in different countries. So I'm actually in a position where I do have some views about that. And one of the issues with the inquisitorial system, and one inquisitor, if you like, inquisitorial literally means questioning. You have one person doing that, is that they can be liable, and have been in some countries, to, for example, bribery or corruption, because it's just one person. Also, some people are better at the job than others, and some people are better, if you're acting as judge and jury, which is really what it amounts to, you may have your preconceived ideas, and you may, in some countries, judges are elected as well, and you want to be elected again next time round.
Keep the favour of the society.
So there are all sorts of ways that system can go wrong as well.
Can fail.
I can't tell you whether one system's better than the other. We have what we have, and I take some comfort in the fact that at least society's represented. Did the judge who's doing the inquisition, who's doing the questioning, did they go to an expensive private school and never see real life? After they left their private school, did they live a sheltered life, or were they beaten up by their bully of a father, or do they go to, and there have been cases of this, go to particular sex clubs where they can be vulnerable to blackmail if they don't come up with a certain verdict. Just because you've got a trained judge doesn't mean you're safe. And again, I say the quality of judges today is so much better than some.
Well, you brought up some very valid points there, because I often raise this with inform people just to try to get a sense of it, people that understand the systems. I get frustrated with the adversarial system because quite often I don't think all the evidence is presented. I'd like to see more evidence presented. What you touched on, what you learnt with your studies with the jury, they seem to be, why don't they trust us? They're putting us in such a powerful position of responsibility, but we're not clever enough to absorb all the evidence. So, yeah, maybe we've got the right system. It just needs some improvements and adjustments. And I love the thought of a facilitator in there, keeping those juries on board, because you mentioned something the other day without referencing the trial, but what the jury came out, because after all the evidence has been presented, if people aren't aware of that, then the juries are sent away to consider their verdict. And what was that one after 3 days?
Yeah.
They came out. What was the question they asked?
This was a murder trial, and it was actually a trial I was involved in as a lawyer. It wasn't one of my study ones. And the jury deliberated for 3 days. In fact, we're all just debating, do we give them more time? Are we ever going to get a verdict? You know, the lawyers and the judge were sort of looking at that question. And the jury is allowed to send questions out to the court. And often what happens, always, except for this occasion, the judge and lawyers will agree as to what the answer should be to the jury's particular question. And but this jury came out after 3 days of deliberation and said, does the accused have to prove he didn't do it? And the judge didn't even bother consulting us. But we looked at each other in horror and thought, what have we been going on about for all of us? Prosecution will tell the jury because of the type of, you have to prove this beyond reasonable doubt. How can you, if you're...
So they've missed the whole
point of it.
Purpose of the...
But I thought about it later and I thought, what's probably happened, and I thought about this after I did my research, what's probably happened is that there's one juror who's being a complete idiot, who won't shut up, who will say, no, the accused got to prove he didn't do it, and he didn't prove he didn't do it, so I'm going to convict. And everyone else is saying, no, it's not how it works. And in the end, they probably said, look, we'll settle it once and for all, go back into court and ask the judge. I hope that's what happened.
Might have been how you would like to think not all 12 of them sitting there debating that. The fact that it's now in courts, not it used to be unanimous decision, like all 12 jurors, but now there's some leeway for certain cases that it can be majority of a decision. I thought that was good because you only needed to have one dropkick on the jury. And it could just, for whatever reason, they might just be a painful person, disagreeable type person, that's going to sit there and argue till the cows come home regardless of what facts have been presented. I think that was a step in the right direction.
It's not the case with homicides. It's still got to be unanimous, and that's because the stakes are so high, and I think that's fair enough. But you can get a verdict of 11-1 or 10-2 now in many others. But this is another example of not trusting the jury. The jury is told, your verdict has to be unanimous. And the lawyers and the judge have all got their fingers crossed behind their backs because they know that if the jury's having trouble reaching a verdict, they'll eventually be told it can be, 10-2 or 11-1. Well, why not tell them that in the first place? And then you get the juries where a juror has been on a jury before and knows that. And they'll tell the other jurors, look, we can actually have a majority verdict. Well, why not tell them that in the first place?
Yeah, give them the information. That makes sense. That does make sense.
And then it shuts up that's Turkey, who's, because the juries will say, we don't have to take any notice of you anyway because it's just one of you.
Yeah, because the chances of getting 12 people selected randomly and you're not going to get a drop kick or a turkey, as you say, on that group, you got to be pretty lucky. You got to be pretty lucky. If people wanted to, the studies that you've done, is it available to the public? Has it come out in any form?
Yes and no. I've written several articles. Yeah.
No, it's either a yes answer or no. It can't be yes and no.
It can. Watch me.
Oh, okay. Yeah. I wish you taught me this trick when I was in the witness box.
I have taught people that trick. I'll just digress and say I teach people what you say is you turn to if the lawyer's saying, I'm asking you the questions, yes or no, give me a yes or no answer. What you do is you turn to the judge and you say, Your Honour, if I were to give a yes or no answer, I would be in danger of misleading the jury. And the jury goes,
perfect.
And they'll never do that to you again. So
Perfect.
yeah.
I like it.
Anyway, that
Very
was
good.
a digression. But now, what was the question again, counsel? That's the other thing. Half the time the lawyer's forgotten the question by then too.
Is it available to the public?
Some is. And you know what? I'm actually, firstly, you can just Google and you'll find some of the publications. Also, if anybody's actually keen to find out about it, I'm actually perfectly happy to be emailed about it. And you will find my email address if you just Google me. So it's pretty easy. There's nothing private about my life or anything.
Well, the fact that you've done the study, like it was something that needed to be done. There's so much value in what was learnt from having access to people that we're not normally given access to. For anyone to do a study, it gives an understanding. It makes sense.
That's why so many bodies were on board with it, and everybody wanted the results.
Just one question. Is this just a myth or a rumour that there was a jury, a person on a jury trying to use a Ouija board to speak to the deceased in a trial?
That actually happened.
I saw that in
That's
some.
Real.
That actually happened. Yeah.
It did actually happen, and what happened was it was a murder trial. We seem to be talking about murders a lot, which is good. And it was one of those circumstantial cases because one of the things about murders is usually the main witness is dead. In fact, invariably the main witness is dead because that's why it's a murder trial.
You usually need that aspect. It's one of the proofs. But,
see, again, dark sense of humour. We're actually laughing about it. But anyway, okay.
I know. People understand.
Let's move on. So the juror thought, well, there's two opposing stories and they both make sense. This could have happened this way, could have happened that way. I know, we'll ask the deceased. And they brought the Ouija board into the jury room and they set about having a séance to try to communicate with the deceased. This was discovered and the appeal was successful. So, yeah.
Well, see... Now, if we had your facilitator in there, that he could have or she could have sorted that one out and go, no, we can't have a séance in the jury room.
That would never have happened.
Not allowed.
Absolutely.
Yeah, but okay, bizarre. Look, there's 1,000 more things that we could talk about. I want to make mention of your book about life, law, and not enough shoes. How did you come up with the title of your book?
Probably through being a girly criminal lawyer. And dealing with all the things that came with being a girly criminal lawyer. And the thing is that shoes don't judge you. Shoes are non-judgmental. Shoes love you no matter what. And, sometimes I just took pleasure in the fact that I could be a girl doing a bloke's job and I could still stay a girl. And I wore some in for you. Haven't been dipped in blood, but...
Right. Okay.
There you go.
Yeah, no, they'd rock it.
And also I got into trouble from a judge for wearing zebra striped shoes once in court because he said it was distracting the jury. I know who it was distracting and it wasn't the jury. And I reckon black and white went with my lawyer's outfit anyway. So
you go, girl. You wear that. Look, there's a lot of other stuff that I wanted to speak to you about, but I think we've only scratched the surface of some of the things you've seen and done. I was going to ask about cruising the world on the QE2, entertaining guests. After sitting down with you for the podcast, I can see why you were invited on cruise ships as a speaker. Just tell us briefly about that experience, because that would be quite. It's not the typical career path that a high-profile barrister goes down, but a talking gig on cruise ships.
Again, it happened by accident, of course, and this seems to be a bit of a theme.
I'm going to start to call you Forrest Gump. You know how he went through his life.
Life's just a box of chocolates.
Okay, how did this accident happen?
I was actually on a cruise, paying for it, and there was this guy.
Had too much to drink at the bar and then started talking. And,
what?
Yeah,
what?
Okay.
Drink? What? Seriously?
Yeah. Sorry.
And yes, you should apologise for that slur on my character. No, I was actually listening to one of their lecturers and he was terrible. He actually got their staff to wheel a desk onto stage and then sat behind the desk and read from a stack of papers. It was awful. And see, I'm carefully not saying which cruise line it was, but it was terrible. And I thought, anyone, not just me, anyone can do better than that. So I asked him how he got his gig. And he said, I've got an agent in Miami and they get me the gig. So I wrote to the agent and said, how about it? And you have to give a bit of an outline of the sorts of things you can talk about. So I gave them a bit of an outline, and of course CSI was all the rage, and I could talk about forensics and crime. And next thing I knew, my first gig actually was on the Queen Mary, and I went from there to all sorts of other cruise lines. And what happens is you go on these 6-star cruises. You don't have to pay. You're treated as a guest. You can take a friend, play your cards right. But no, you'd have to share a room with me. You won't want to do that. And I have to talk about stuff I know about. But the other cool thing about it is these audiences are usually quite no one's forcing them to go to lectures. They're choosing to. So they want to learn. They want to know about this stuff. And it's been some of my most satisfying teaching moments because I've done a lot of teaching over my career. People will go out and say, I'm thinking about things differently from now on. I have this thing called ABC, assume nothing, believe no one, check everything. They said we're going to be more critical in a good sense of the word. We're not going to take what the media tells us at face value. We are going to ask questions. We've learned a different way of thinking, and that just gives me such joy.
Well, what a great gig you got there, and I can imagine you would be very popular and entertaining for the people listening to your talk, because I've got a sense of the way you tell a story from our sit down today. So, I want to thank you so much for coming on the podcast. How do people get your book? Is it
the only way now is you have to actually. Again, Google me, go to my website. You can order it there or flick me an email. It's out of print now. It went to 3 print runs, I might add, and it wasn't vanity published either. It had a real publisher, so it's a real book.
Oh, you're the real deal.
I am. Yeah. So you can contact me, and while stocks last, I can post the book or get it to people. The publishers have an option on another book, so I guess I better get around to writing another one. So we'll get out there.
You better sit down and just concentrate and start getting those words on the page. I got it on Kindle, the book.
I don't make any money out
available
of that. Thank you very much.
Well, sorry, forget that, delete that.
No, it's all right, it's fine.
Don't mention that.
Because I do honestly have the last remaining stocks. I've only got about 50 or 60 left, so people might be forced to get it off Kindle anyway, so I don't really mind that much. It's okay. Yeah.
Okay. Well, thank you very much. And I want to thank you for the work that you've done, because I know having people that genuinely care in the justice system makes a difference, from police, the victims, everyone involved in it. And I can see you care, and you're smart. You've got everything that people need. And I can see why people were lucky to have you defending them if they got into trouble.
I'm no good at compliments. Taking.
If I do get over to WA a bit, if I get into trouble, I know who I'm calling. Not that I'm ever going to get into trouble again. I've had enough of that. I don't want to be in a court again at this stage, but I'm sure I will be. Okay. Thank you very much.
No problem at all. Okay.
Cheers.